dispute resolution part. Haven't changed in 15 years.
Right, yeah.
And so that's what the goal is to make
Good afternoon. We're at the Governmental Affairs, and this is our full committee meeting. Make sure everybody's in the right place. Before we get started, let's see, Representative Anderson, would you give us a prayer?
If you all will bow with me. Dear kind and heavenly Father, God, we thank you for the blessings that you bestow upon us each and every day, God. We thank you for being allowed to live in this state, God, in this nation, Lord, and in this time, God. We pray that your guiding hand will be on our leaders, God, and we pray that your mercies will be on those in Ukraine and overseas that are dealing with issues, God, that we can only imagine, Lord. God, we thank you for your blessings again. We ask that you'll be to guide this body and our decisions, and let our decisions all be with your guidance. In Jesus' name, amen.
Thank you. And our first presenter today is a little out of order, but we are going to have Senate Bill 346, and that is because of the distinguished gentleman from the House that will be carrying it. So please go to the podium.
Well, thank you, Madam Chair. Appreciate you letting me come here. I am presenting this bill on behalf of His Majesty Senator Jeff Mullis of the 53rd Senate District. I'll give you a summary. I think y'all already had this in sub. I'll give you the summary of the bill. If y'all want to, we can dive into some details. But in summary, this bill prohibits a state agency from contracting with any company owned or operated by the government of China. Requires every company submitting a bid for a contract with a state agency to certify it is not owned or operated by the government of China, and institutes a penalty for any company which submits a falsified certification.
Thank you. Just to make sure, will you read your LC number so we can make sure we're all, this is a committee sub.
It is a committee sub, and Madam
Would you
Chair,
like me to read the number?
please?
Okay, we're working off of LC 442035S. Are there any questions for the gentleman? Okay, we have Representative Bernal.
Thank you, Madam Chair. I wasn't, that's not my subcommittee. Why did you all pick China? I'm just asking.
Well, a couple of different reasons,
Okay.
and I can kind of go into some details here. Madam Chair, I may be suffering from delirium, but I believe I'm hearing myself. And I don't know if it's this one on this shoulder, that one on that shoulder, or another one from somewhere I don't even know.
Just don't answer them back.
All right. My wife gives me the same advice, so I'll take the same here. The question was, why are we doing this in China? So we're impacted by these technologies. And so some of these technologies that we're seeing that are being deployed by China, namely, we got here some of the Chinese drone maker DJI, which controls about 50% of the US drone market. They're collecting troves of information, and the US Treasury actually put it on an investment blacklist. And so we're seeing this with all sorts. I believe Huawei phones is one of them, and several of these kind of electronics that the Chinese are pumping out are actually collecting data from Americans and sending them back to Chinese databases and government databases to collect information on US citizens. In fact, there was even some discovery in China during the last Olympics that just happened in China, and where they were actually drawing down information on United States citizens and others about personal information on their phones and et cetera. So we just got to be careful. Again, we've got US agencies that are doing the same thing, that are blacklisting the same kind of information, the same kind of stuff. We just need to be able to protect our citizens that against a regime who wants to, economically or otherwise harm the United States and vicariously the state of Georgia. Thank you for your question. Yes.
All right, we have a question on Zoom from Representative Nguyen. If you unzoom.
Thank you, Madam Chair. I have a similar question to what Representative Bernal just brought up. Do we have restrictions on any other countries?
As far as the state of Georgia goes,
Yes, as far as the state of Georgia.
I couldn't speak to another country. This is a bill that is formulated based on the country of China. So you may know of one, but I'll stick with the content of the bill. This is about China. It could be, presumably or presumably not.
Thank
Yeah,
you.
and I have a follow-up. What's the process by which we determine which countries are dangerous for us to do business with?
Well, I think if I may, I'll give you an example. So early last month, FBI Director Chris Wray said in a speech that no country presents a broader threat to our ideas or innovation and our economic security than China. And the threat is fueled by a high U.S. demand for Chinese-made products that open back doors to intrusion. And I'll go into some detail, Madam Chair, if you indulge me.
Go
I
right
have
ahead.
some written up. I know that y'all talked about this during the subcommittee, but if you indulge me, I'll go through some of these other details. That backdoor risk comes from China's 2017 Internet Security Law, which gave the Chinese government access to information collected by equipment provided by Chinese-owned companies. The level of risk the use of China-owned technology presents to our national and economic security is so high that it is restricted by the U.S. military, the State Department, and our intelligence agencies and other departmental groups. But these restrictions, Representative Nguyen, however, they don't transcend to our state level. And if states unwittingly purchase these products through their government offices, infrastructure, and even personal data, are then vulnerable to these Chinese-based attacks. So we're kind of seeing this on the federal level, where these state agencies are saying, "Hey guys, this is a problem," and that's why we are looking at China as a major actor for vulnerabilities in IT and otherwise.
And I have one more follow-up, Madam Chair. Do we intend on looking at other countries when it pertains to making these decisions? I mean, obviously at the top of mind would probably be doing business with Russian-owned companies.
Yes, that's correct. So we are looking at Russia currently, and we should have something for this committee within the next couple of weeks. That's correct.
Thank you. Let's see, Chairman Oliver.
We have do we have today a Office of Economic Development on behalf of Georgia in China? Yes. And we have done a deep dive into the Russian assets for Georgia's investments, including the pension funds, and found, Chairman Stevens, how many hundreds of millions of dollars of Russian investments are in our pension funds. And when we take them out, we're going to drop for a gazillion percentage. What have do we got that real number? So I am convinced that China is doing espionage in this country. I don't
Amen.
understand how they do it, and
It's fine.
I'm not going to try to learn. I'm convinced they do it. But at the same time, through Georgia ports, China is what investment they're making in the United States of America? You would know, billions. So now we're doing this. So put those two things together for me and explain to me why we're funding an Office of Economic Development and doing billions of dollars of work with China, but we want to do this too. Explain that dichotomy to me.
Well, I serve in the legislative branch, not the executive, so I could not speak for the ports, but I will speak on behalf of this legislature, who I believe wants to start putting a tamp down on China and other Russian actors who are stealing our information. So I really can't speak to the economic development or anything else. I'm sure if y'all want to pull experts in here, y'all could do that. But I'm
Because
speaking.
I'm conservative about money, I'm just kind of curious about what the
Sure.
dollar value of this bill will be to the United States, to Georgia, along with the Russian actions. I might be for it,
Sure.
but before I vote yes or no,
Sure.
I just like to know what's the financial impact of this plus the Russian money,
I think
because I'm
it-
conservative about money.
Sure. And Madam Chair, if I may, I'll say that I think that the personal data and the data of millions of businesses in the state of Georgia. Their employees and their customers are priceless. And it's time we do something to make sure that we protect those bits of data that are sitting on servers by making sure that Georgia takes the lead on making sure we're not going to do no business with China.
Raises another interesting question if we ever got to a point of really analyzing this. What's the dollar to value? What is the facts of personal access to my personal data? What's the facts? And what does that cost versus the cost of this action? Just don't want to understand the money about what we're doing.
Madam Chair, I can say that I own a phone and I own a computer and they are in my office. More than that, I reckon answer your question. That's a pretty technologically advanced, and I'll
Thank
give you
you.
that. Thank you.
We have on Zoom Representative Maynard. If you would unmute.
Okay, sorry about that. Thank you, Madam Chair. My question is, it's a comment and a question, actually. You know, we have heard a lot about what China is doing as far as using data and not going by, I don't know the proper word, but not going by etiquette to keep our data safe. And I just wanted to make a comment that even the schools, my children, there's an app that a lot of children are using called Snapchat. And we were advised on that particular app, do not let your children be on that app because of the information that the federal government has advised that they're stealing from the consumers that use Snapchat. And it's also, my daughter's right here next to me. She also said TikTok as well. So there are apps, especially with children, where they are taking children's information. So that is definitely of concern to me. And I had to tell my children to uninstall those apps.
Thank you. Representative Burnell, you have another question?
Thank you. I kind of understand what you're saying. The reasoning, I don't completely agree with it, because if it's China now, are we just going to go from country to country and start just saying we're not going to do business with this person, that person? Because it's not just China, but then they'll say that there's certain companies within the United States. So are we going to go through those and see which ones of those might be stealing our information?
That's right. So I think this is a healthy start. You know, when we talk about China, we know they're a known actor, right? So the first thing we do is we look at the U.S. Department of Defense. So we got, they're banned by the U.S. Defense and Intelligence agencies already. And that, to me, given that they're already, banned by the administration that's there, tells me that we need to take action on this to make sure that our data is not vulnerable.
This doesn't have anything to do with elections, right? I just want to make sure this is about elections,
No,
or this
this-
is about personal information?
This is about, there's certain types of phones and devices, things like drones and others that are collecting data, right? And they're beaming those back to a server,
Okay.
right, in China. And that phone or that device or whatever it may be has your information. Could be location data, could be financial data, could be your purchasing preferences, or could be your bank account number. And so what we're saying is if the U.S. Department of Defense and these other federal agencies have already blacklisted these devices and these manufacturers, then we need to follow suit, right? And make sure that we're protecting Georgians' interest, their data, their privacy, and security. Thank you very much.
Thank you. Representative Shannon on Zoom, if you would unmic.
Thank you, Madam Chair, and thank you for giving the additional context today, because in subcommittee, none of this was discussed. And it kind of led me to believe that this was more of a bill of just kind of telling businesses who they could do business with based on a country's values. So I do appreciate what you're saying today. My question is, has there been any movement on, it just seems weird that this would be coming through the General Assembly for us to make this decision. It seems like Homeland Security or some agency at the federal level would be making this decision about which countries you just should not do business with. So do you have any information just around, what Homeland Security says about this? I know you mentioned Department of Defense. Why hasn't there been some type of action on the federal level to really tell us this? And do we have the authority to decide this? So it's a two-part question.
That is a great question. So right now, there is no central or state local vetting agency. So states and local governments, they just don't have the expertise and they don't know the risk. And furthermore, the National Association of State Procurement Officers, the NASPO, which is highly regarded as the gatekeeper for state government purchasing across the United States, they are not currently accounting for these security vulnerabilities. So that's a great question. I think that's a question that we all have to start answering together as these kind of blind spots are presented to the states. And again, we have to, at the highest levels, protect the data, the security, financial information of Georgia citizens. And if that means that we got to start looking at these devices that are taking this information and knowingly by these defense departments and intelligence agencies, they have submitted these reports already and blacklisted them. And let me highlight that. So in July of 2019, the Department of Defense Inspector General highlighted $33 million in purchases by the Pentagon of commercial off-the-shelf Lexmark and Lenovo products, which have been put on a registry of National Vulnerability Database because of security deficiencies. Like Huawei and ZTE, Lexmark and Lenovo are Chinese-owned and banned by multiple military and intelligence agencies in the US and around the globe. So yes, this is a blind spot, and this is the blind spot that this bill is looking to fill.
Just a follow-up, Madam Chair, if I may.
Go ahead.
Okay. So with what you just said about the resources that it takes to kind of be aware of everything that's going on, and I'm not sure what type of resources are required to research exactly who owns, what business. I'm assuming that not all businesses where we're seeing things happen that we don't want to see happen are being truthful about who really owns it. So I guess my question is this feasible for a sole prop or for an LLC to really be able to figure out exactly who owns a business if there's any type of deception involved? Because the fines in the bill talk about $250,000 fine. I'm just wondering how easy it would be for a sole prop or a smaller business to make sure that the information they're submitting is correct.
Now, I want to make sure we're on the right page here. So we're not talking about private companies. We're talking about state agencies. So a state agency could not, that's where we have, right, the ability and authority to start regulating these. And so we're talking about state agencies, not small business owners.
Okay, thank you.
Thank you.
Thank you.
Okay, I have no more questions. At this time, I will entertain.
Madam Chair, I'd make a motion to pass.
Do I have a second? Okay, we will ask all those in favor, please say aye. Any opposed? We've got one opposed. And let's go ahead and take it online. If you would unmute and let's see, Representative Maynard,
Aye.
Representative Shannon,
Aye.
Representative Williams, Representative Williams, Representative Nguyen,
No.
Representative Powell, Representative Sains.
Aye.
The ayes have it. Your bill passes. You're on to rules.
Thank you, Madam
Thank you.
Chair. Appreciate y'all.
Thank you. Next, we will have Chairman Stevens. If you will come forward, I think you have a couple things for us.
I do, Madam Chairman. Thank you very much for members of committee and chairman. These two bills, I'm embarrassed to tell you, I thought was already law. Both these bills came out of the recommendations from the Rural Development Council, of which you're a member. The first bill, House Bill 1381, LC number 471628, requires 4 hours of continuing education for water and sewer Authority members to be completed before July 1st of 2023, before they can receive any more money from from GEFA, the Georgia Environmental Finance Authority. This is can be done in person, can be done online, but it is a minimum requirement for these folks that have bonding capacity to send out, if you will, debt with some requirements for continuing ed. For example, the definition of what a bond or bond indebtedness or that sort of stuff. So that's what the 1381 does. It's very simple. Minimum requirements, 4 hours of CE.
Do we have any questions from any of the members? Representative Leverett?
Thank you, Madam Chairman. Thank you, Mr. Chairman, for these bills. I think these are very important, but just to make sure it's 4 hours one time, not periodically. Is that
As I
correct?
recall, it's annual.
It is annual?
Yes. Let me get the language here.
It is.
In the preceding 12 months satisfactory completed 4 hours of continuing education courses. Yes, it's 4 hours period.
That's my understanding.
Yes.
I'm fine with that. I just want to make sure it was not a periodic annual 4 hours annually.
Every member, even new members, is one person, 4 hours.
Okay.
Oh, yeah, okay.
Okay, Representative Bernal?
Thank you, Madam Chair. What brought this about? Was there a reason? I mean, did something happen with the board members?
It came up as a recommendation from several of the meetings that we had on the Rural Development Council.
Okay,
That this was a glaring lack, if you will, between the water and sewer authorities and the next bill that I'll get to, that just required folks to have some knowledge whenever they're extending debt on behalf of the public, non-elected officials in most cases.
thank you.
Okay, let's see. Representative Collins, Chairman Collins?
One quick question. As far as who is going to sanction these credits, is that going to be GMA or GFA? Who's going to?
That the bill does not address that. As long as you've got continuing education in regards to the water and sewer authority, then
So
you're covered.
it's going to fall to the Water and Sewer Authority to decide what
Correct.
level of training that this is going to be. So this is not something that's going to be done through GMA and have some type of accreditation.
ACCG and GMA
Right.
can both participate.
Okay.
Thank you. Are there any further questions? I don't see any. I will entertain a motion. We have a move and a second. All those in favor say aye. Any opposed? We'll ask those that are on Zoom. Representative Maynor,
Aye.
Representative Shannon,
Yes.
Representative Williams,
Aye.
Representative Powell, Representative Nguyen,
Aye.
Representative Sane, and Representative Gullett. Okay, the ayes have it. Your bill passes. You're on to rules. And I believe you have a follow-up, another one?
I do. This is House Bill 1382, which has to do with the development authorities in Georgia, which will require 8 hours of continuing education before they can receive one Georgia authority money. This is, as you might see, beginning on line 18, again, after July 23rd, the directors and the members shall complete the training provided for this subsection and shall attend at least 4 hours of continuing training, development, and redevelopment each year. And that's the one that has the yearly provision in it. And this, of course, before you'll be able to access money from the One Georgia Authority.
Are there any questions for the gentleman? I see none. I don't see any. I will entertain motion. We got a motion and a second. All those in favor say aye. Any opposed? We will unmute and we'll go down our Zoom. Representative Maynor,
Aye.
Representative Shannon,
Aye.
Representative Williams,
Aye.
Representative Powell, Representative Nguyen,
Aye.
Representative Saines,
Aye.
Representative Gullett. Okay, the ayes have it. Your bill is passed.
Thank you, Madam
On to
Chairman.
rules. Thank
Members
you.
of committee.
Okay, our next bill is going to be House Bill 1405. Representative Roberts, if you would like to go to the table. And if you would, please identify your LC number.
Thank you, Madam Chair. Colleagues, we are working off of LC 471698S. I appreciate your consideration today. This bill essentially amends the zoning procedure law to clarify the process and procedure for challenging and appealing certain land use decisions. And bear with me, I'm going to try and give you all some examples. They're basically broken down into legislative and quasi-judicial. And we'll start with quasi-judicial. Let's say you had a developer who wants to build a subdivision on a tract of land that is zoned agriculture. You would go to the local legislative board, county commission, city council, and you would file a zoning application and ask that it be changed to single-family residential. If you were to challenge that decision up until 2017, the law had been very clear that it would be by what's called de novo review, meaning that you get to essentially put on a whole new trial, present evidence, witnesses, cross-examine witnesses. One of the things you often have to prove is diminution in property value, so you need to put appraisal stuff on. So if any of you have been to your local county and city council zoning meetings, you know that typically the applicant and the opposition only get 10 minutes to present their case, and it would be impossible to put on a full evidentiary hearing at that time. In 2017, the Georgia Supreme Court kind of mucked it up a little bit, and then a couple of cases after that. And so I'm a land use lawyer. My law partner is the one who appeals these. But essentially what we're finding ourselves doing is preparing huge notebooks to submit to make sure that we've got evidence in. And we're preparing these lawsuits in two different ways, which is expensive for the citizens, also expensive for the counties and the cities to defend them. Just trying to figure out how not to lose our due process right and to make sure that this particular judge is going to agree with the way that we file it. So the purpose of this is to take us back to what the law was prior to 2017 and just bring it by a deck action, and de novo review would be included. Okay, so that's the first piece. The second piece is in the quasi-judicial arena. And an example of that would be if you wanted to put an addition on the back of your house and you didn't have enough room outside of the rear yard setback. So you would go to your local zoning review board and request a variance. So your county commissioner, your city council, they appoint these lay people normally to these boards, and they act essentially as a quasi judge. And there's very specific criteria that they apply to determine whether the variance is approved. Those have always been brought by what's called certiorari, and we're not changing that. But what we are doing is trying to make that process a little easier for folks to bring, because it's always been complicated to find somebody at the county to sign the cost certificate and the bond. A lot of times the board's members have to be served, and because they're not at the county 7 days a week or 5 days a week during normal business hours, the county doesn't publish their home addresses. So sometimes it's hard to figure out how to get service on them. All this is going to do is require the cities and the counties to amend their zoning ordinances to designate the person who will receive or who will sign the cost certificate, the bond, and accept service on behalf of the board. And that way we're making sure that everyone isn't getting their due process rights, because it's not through anybody's fault. COVID has really exacerbated this as well, finding somebody to sign these things. And I should tell you, it's a very technical process. And if you do not follow it to the letter of the law and it has a quick turnaround time, it's not amendable and it can be dismissed immediately. So that's why this is important. We my partner and I, we sent this around to other land use attorneys, city and county government attorneys, and got their feedback. And then we've sent it to ACCG, GMA. We've incorporated every single change they asked us to make. The Georgia Realtors are on board. Everybody is on board because essentially what this is going to do is just clarify the law, make it less expensive for the citizens and the counties, because everybody will be clear on how these actions are to be brought. So I would ask for your favorable consideration.
Thank you. Does anyone on the committee have a question? Okay, let's see, Representative Oliver, or Chairman Oliver?
I'm
Yes.
thinking that the equivalency in my mind is the Historic District Committee in Druid Hills that has to approve variances and that kind of.
Correct.
thing, Which is quasi judicial. They say yes or no. So that makes sense. to
Correct.
me.
Yeah,
This sounds like good streamlining. then. Thank
it
you.
is. Yes.
Representative Leverett, do you have a question?
And I'm sorry, I was having trouble keeping up. So if it's, if it's quasi judicial or legislative, that tends to determine the manner in which you appeal right now.
They've
Under
always
existing
been
law.
appealed differently prior to 2017. Legislative is by this de novo review, you file a declaratory judgment action typically. But then the Supreme Court kind of mucked it up. And so some counties say it has to be by certiorari, some still recognize it the other way. So we're preparing basically two lawsuits when we're doing these, and which just trying to guess on which way the judge.
The
will go.
idea being the county can now by ordinance specify the means of appeal. Is that right? In both cases or in any case? having to do with-
Well, the zoning procedures law would, that were the changes that we're making would designate that the legislative are back the way they used to be to de novo. And then we're not changing the certiorari process for quasi judicial. We're just making it so that it's not frustrated for people to actually accomplish the process.
Okay. And now I've got a bill that actually would do away with
So
the cert petition for cert. Of course, it ain't law yet, but I'm hoping it will be.
So my husband reviewed that and it didn't look like y'all repealed the certiorari. Because I told you I was going to go back and look at that. And so I'm not sure that it does. I think we need to take a little bit of a look at
I
that.
think it deletes the whole article that deals with petitions for cert. At least that's my understanding.
That may have been the
wouldn't
intent. I'm not sure that that's the way it read when we looked at it, but
Okay.
yeah,
So
we can talk about it more if you
I
want
guess that's
to.
something we need to resolve. But so what you're proposing to do is go to pre-2017.
Just on the legislative,
Okay.
and that's just saying you get a full evidentiary
novo
review in
Petition
front of
for
the
equitable
judge.
relief
Correct.
In Superior Court.
Correct.
Okay.
And then on the certiorari, if you do away with it, I guess you do away with it. But on the certiorari, if it doesn't get done away with, then I just want it to be a process by which the public and citizens can actually exercise their right.
Well, and the bill I've got would just change it to a petition for review, which is much clearer and simpler than the petition for cert. You wouldn't have all that bonding requirement. You wouldn't have to sue the judge. You wouldn't have to do any of that stuff.
Did you intend for that to be on the record though? Or because generally a certiorari for a variance, because it's quasi judicial, you would only review the evidence that was in front of the zoning review board, the historic commission. I'm not sure your bill reads that way, so I don't know what you wanted it to be.
No, I don't think it does. I think it tries to preserve whatever the current state of the law is with respect to whether it's de novo or not de novo.
Okay,
At least that's the intent, I think.
Okay.
It's intended to change the general process by which you invoke the jurisdiction, so it's not so Byzantine. as
it is,
just
I agree with
absurd.
you, certiorari is Byzantine. I won't argue there.
All right, so maybe we can have that conversation.
I would
after.
like to do that.
Thank you. Representative Maynor online, if you would unmute.
Yes, thank you, Madam Chair. Representative Roberts, you might not know the answer to this, but do you know why it was changed in 2017? What were they finding was wrong in 2017 to make them change the law?
I'll be honest, I just don't think it was the best decision. And it just really confused a lot of folks. A lot of zoning attorneys who've been doing this for years, who have followed this same set for a long time. So
Was it, excuse me, was this, it wasn't a new law, it was a decision?
This
from the
was a
court.
Georgia Supreme
Okay.
Court, yes.
Thank you.
Okay.
Okay.
Is that all?
Yes, I guess I have a follow-up then. I'm sorry. So the
Okay.
Supreme Court decided to make this change? Is that what you're saying?
They confused the issue for sure, yes.
Okay, thank
So
you.
now some counties say a challenge to a zoning goes up by certiorari. And so now citizens and lawyers and even the counties and cities are confused on how to bring the case, even though it's always been by de novo, because it's impossible to put on a whole trial in 10 minutes. That's the point.
Okay,
Thank
thank
you.
you. You have one more, Chairman Fleming?
Thank you, Madam Chair. Counselor.
Hey, I'm not the litigator. My law partner drafted this, so I know you're gonna.
Who who authored the 2017 decision?
I don't remember, to be honest.
That's a good answer. I was trying to find, and I did find, I think it's line 223, your noted, I mean, your service provision.
Uh-huh.
And so what we're saying, how does this change the current service? That's what I wanted to clarify. What is the current service and how does this change it?
I think usually it requires personal service, and we're
Okay.
essentially saying that the county and city can designate someone to receive that for those members.
So basically what you're depending on them to do that, because if they don't, you're back to the same problem.
Correct.
Okay. That's what I was trying to figure out. Were you mandating or were you allowing? And I think you're allowing them to designate somebody, which is good. First time I ever got served with a lawsuit after practicing law for about 5 years when I was chairman of the county commission. And deputy came to my office and everything. So it's quite exciting. We took pictures. And then the other question I had for you, Madam Chair, if I may, is I was also thinking about Representative Leverett's bill that we had the judiciary that deal with the issue that you were discussing. Are y'all in the same code section?
He's in chapter 5, the
Okay.
appeals, and I'm in ZPL.
Okay, but they reference each other and that's what we have to figure out.
They do.
Yeah,
And
that is something.
my law
that-
partner is good. I asked him to go back and look at your bill and provide comments because he was worried that, yeah, so we can talk about that.
So, but appreciate you trying to figure that out for us because we don't need to send two
No.
bills to rules that are gonna not jive with each other. It happens occasionally, but not when we know it.
Right. His review was that it didn't repeal the subsection for certiorari. So we may want to look, and if that was your intention, then we want to, and then we can adjust mine to remove that part if we need to, but
I appreciate you working with the GMA and ACCG on this. I
Absolutely.
asked and they said you've been very accommodating. Thank you.
thank you.
Thank you, Madam Chair.
Thank you. Representative Leverett, did you have another comment?
I did. I was just going to say to the extent that if it turns out we have done away, which was our intent, I still think the two can be easily reconciled because they're just a different appeal process rather than writ of cert, which I think would be easier. And to the extent we need to address the de novo nature of it, we can do that too in either bill, I would think.
Okay.
Thank you.
Thank you.
Gentlemen, we're not in judiciary. Yeah, I hope y'all have had fun. Yes, it does. Okay, we don't have any more questions. I don't see any comments or question. I will entertain a motion. Okay, we have a move. Do we have a second? Okay, all those in favor say aye. Any opposed? Okay, let's go online and see what we've got. Representative Maynor, if you would all unmute.
Aye.
Representative Shannon,
Aye.
Representative Williams,
Aye.
Representative Powell, Representative Nguyen,
Aye.
Representative Sane,
Aye.
Representative Gullett, Representative Gravely.
Aye.
The ayes have it.
Thank
You
you.
are on to rules. Thank you.
Thank you, Madam Chair.
Okay, we have House Bill 1406.
Madam Chair, thanks for allowing me to come today. And for the longest time down here, I had been able to avoid sitting in a judiciary meeting until just then. I do thank you. Madam Chair, can I ask the chair, do you have the bill? When we spoke in subcommittee, the gentleman was going to create a bill and direct it straight to you. So you may
Yes.
have our current LC number. I don't actually have a copy of the new one. I know what the changes we made
Okay,
were,
we will
but-
get you a copy of it, and I will go ahead and tell you, we are all working off of LC 471696S. And I believe that's the correct number.
Yes, ma'am.
Please go ahead.
Yes, ma'am. Well, I'll start because we're in full committee and to briefly explain the bill, I guess as a whole, we won't have to worry about the knot changes or the two knots we deleted. Ladies and gentlemen of the full committee, what we're seeking to do here is relieve some pressure that happened, I guess, in our capital city here, a few months ago, six months or a year ago, where there was, I'm sure he was well meeting a member of the Atlanta Council that brought in some pretty extensive changes that to the zoning code, some wide sweeping things to change single family zoning areas at large. And we don't want to stop cities from doing that. It's a home rule issue. But so this bill just really seeks to ask them to do a few more things than they would do to have two meetings. We had originally had in the bill that there would be three, but in working with the city of Atlanta and Georgia municipal associations, that they would just have two public hearings. They would have two council meetings, not less than 28 days before. So just some reasonableness in the zoning code for large scale matters initiated by a city to make sure people had a sense of transparency. So really what we have here is, and I'm proud to say, I believe, Madam Chair, I can say that the city of Atlanta testified at subcommittee that they had worked with us and we have found a good balance between transparency and allowing the city to continue their home rule so that we can move forward and be good neighbors with one another. So that's what this bill seeks to do, is provide a little added transparency to major zoning issues initiated by a municipality. If you look specifically on lines 55 through 58, it would not apply. The new criteria would not apply to owner or authorized agent initiated zonings. Happy to go through it in detail, but I know the hour is late, Madam Chair.
Do we have any questions? I don't. Okay. Representative Roberts.
The zoning attorney has to have a question. So I guess I'm trying to understand. My email blew up this morning with emails of people opposing this. And so I guess I'm trying to understand, this doesn't just impact Atlanta. It impacts any local government across the state. Is that correct?
It does.
Okay. And so it is essentially a preemption bill.
It is not,
How is it not?
because it doesn't preempt them from doing anything.
But you're putting the state is putting something added on local governments instead of letting them determine what they want their zoning process to be. Is
No,
that
no,
correct?
ma'am, we do what we do. What we're doing in this case is asking them to do more notice and for transparency, much like they would do for a charter amendment. That when they do a massive change to a current zoning classification, we just ask them to notify all the people that are being affected by it. We do not preempt them from doing that.
Okay.
Okay. Representative Fleming. Chairman Fleming.
Thank you, Madam Chair. I think Representative Martin just responded to what I was asking. We do in Georgia code regulate issues of notice required. And that is what this goes to. It doesn't go to their ability
That
to
is correct.
change it. It simply says who and how they have to go about notification. And it also doesn't apply to anybody but the government.
That is correct.
So when a citizen comes forth and wants to rezone their property, there's the standard procedure that they would go through with notice and whatnot. It's only when the government is going to take this action and it's not initiated by someone other than them, correct?
That is correct. And what that extra is, Chairman Fleming, is to provide a little bit of extra notice, to provide notification on all the properties that are involved. We originally in the bill had that every property that was going to be affected had to be noticed. In talking with the cities, they felt that was a bit onerous. So we said if it's over 500 parcels are affected, we'll allow a notice to be put every 500 feet. We're not trying to make it impossible to do. We're not trying to make it, untenable to do. We're just, people deserve to know if they're living in a zoning classification and significant changes are being made by their government to the zoning classifications they live in, because arguably they have a vested right in that zoning, and they should be aware if there are discussions to be made. One of the things I might also add is the bill originally asked for 3 public hearings. In talking with GMA and the city of Atlanta specifically, they can change their charter in 2. That's a pretty major change to everybody that lives in the city. So we went with two public hearings. So we tried to be very reasonable, but I think it's absolutely fair for governments to be open and transparent with their folks if they're trying to change that.
Thank you.
Yes, sir.
Okay, we have one question from Representative Nguyen.
Thank you, Madam Chair. I have similar questions to Representative Roberts. I definitely agree that the public should have notice and be involved when there are major changes. But with this, and I understand City of Atlanta's position, but for other municipalities and counties, would this be more restrictive than what they already have on the books?
I'm not sure I understand. It would apply to everyone if they are doing a zoning ordinance to revise a single family residential use to authorize multifamily uses in a zoning classification. That fundamentally changes the nature and the use of that property. So regardless of the size of the city, if they take a property that's classified as single family zoning and they wish to make a change and say that's no longer single family, we want to make it something else, it would affect all the cities in Georgia to let the folks know that own those properties that they were being impacted. So it would apply equally, but that's a fairly significant decision. Most everybody, I believe, and then the number of people here are working zoning, either for the government or privately, that it's a fairly well-recognized process that once one gets a zoning in a municipality or a county, that's a vested right in your property. And I would argue that a single family zoning is a vested right as well. And one would have every right to consider that if they're changing that and even adding density, that they could take that if the owner felt like that was a cost to them, that they could, make an argument and wanted to speak in a public hearing that could be considered a taking of the property. So that's all we're trying to do is have a conversation and, be good neighbors. Let the government be good neighbors to people.
Yeah, and Chairman, I guess I was just trying to better understand. I know that City of Atlanta has a process in place and that the city is amenable to the substitute version put forward. I just didn't have an understanding of other places in Georgia and what local municipalities are doing with their zoning requirements and just what the pulse was all around for other cities.
Sure. Well, I have had conversations with representatives from the Georgia Municipal Association. I've had conversations with individual cities, and I can't speak for their 450 plus cities in the state of Georgia, but I haven't found a single city that talked to me that has a situation whereby they were doing a wholesale change to a zoning classification. Cities might on their own initiate a rezoning from an R1 to an R10 that might be single family to multifamily, but I didn't find one that I had spoken with that would have just fundamentally changed R1 to all of a sudden allow multifamily zoning in that zoning classification. They might rezone a property, but they wouldn't change the zoning classification So I didn't find anybody else. And to be honest, again, I think the council member in Atlanta might have been well-meaning, but I believe that what happened was withdrawn because that wasn't necessarily an overall great idea for the city of Atlanta at large. And this just says if that were to come back, that people would know about it.
Okay, we're going to have one more question.
Okay,
Representative Roberts?
so this is just for text amendments is what you're saying?
Well, text amendments was introduced to me last Friday. I was in local government for 10 years in Alpharetta, and I never heard of a text amendment. So.
Well, just to clarify for Rep. When usually those only require publishing them in the newspaper. So I am a pro-transparency person.
Right.
I guess what's bothering me is that we're just focused on single or on multifamily. And so I don't know, it would seem like if we were trying to provide transparency when the government was taking action to somehow change use of property, that maybe we should do it wholesale instead of on one particular use. But anyway, that's my 2 cents.
Representative Anderson?
Yes, motion to pass.
Okay, do we have a second?
Second.
Representative Roberts?
No,
Oh,
I didn't
you're-
mean to.
Okay, thank you. All right, we have a motion and a second. All in favor, say aye. Those online, if you would unmute and give your aye.
Aye.
Representative Shannon?
No.
Okay, Representative Williams?
Aye.
Representative Nguyen?
No.
Representative Gullett? Representative Gravely? Were there any no's? Okay. We have one no. Okay. All those in favor, it does pass, so you are on the rules, and we have one more bill. If you would, please. Representative Anderson?
Madam Chair, in the interest of time, since we got this room for about 40 more seconds, I'll do my bill from here if that's okay.
That, please do.
Okay, House Bill 1385 LC 471682S. In our annexation study committee out of session, we identified several issues that we're addressing, but this particular bill addresses one issue. Currently, when a municipality annexes property, they are required to provide reports, maps, et cetera, to the Department of Community Affairs. There's no additional requirements. So what we are doing is we're basically adding 3 things to that provision. We're adding that those maps also be provided to the Legislative and Congressional Reapportionment Office of the General Assembly. Secondly, we are specifying a format that the mapping data is added, is provided in, and that's shapefile forms, which can be imported into mapping software. And third, if a municipality does not have the capability to generate those shapefiles, we're allowing them to seek assistance with the regional commission. With that, answer any questions or ask for a favorable review.
I don't see any questions. Are there any questions online? Nope. Then I will entertain a motion. We have a motion. Do I have a second? All those in favor will say aye. Any opposed? Okay, online, if you would unmute, Representative Maynor,
Aye.
Representative Shannon,
Aye.
Representative Williams,
Aye.
Representative Nguyen,
Aye.
Representative Gullett, Representative Gravely.
Aye.
The ayes have it, and your bill passes, and you are on to rules. And with that, we are adjourned.